All right, good afternoon, everyone. My name is Deanna Fenton, Program Manager here at the Alliance. And as always, it's my pleasure to introduce today's program, which will focus on the legal and ethical framework surrounding donation after circulatory determination of death. We're joined today by two very knowledgeable and well-versed attorneys who have offered their time and expertise. But before I go ahead and turn it over to them, I'd like to take the next few minutes just reviewing a few general housekeeping guidelines. When accessing our webinars, we do highly recommend using the Chrome browser to ensure an optimal visual and audio experience. So if you're already using Chrome and experience any audio issues, we do recommend reconnecting to the webinar using the phone number that was provided in your confirmation email. Should you need any assistance, please feel free to contact a member from the Alliance team. Additionally, throughout the duration of today's presentation, your audio lines will remain muted so that we can ensure the best audio quality. That said, we ask that you take note of the chat feature that's located in the bottom left-hand corner of your screen. This chat will be used to pose your questions to our speakers. So if you have any questions that come up during the course of the webinar, please feel free to submit them at any time. Once the presentation has concluded, we'll go ahead and transition into our Q&A discussion, where our presenters will address as many of your questions as time allows. Now, for anyone interested in our upcoming webinars, please note registration is currently open for our next transplant webinar on Life After Regions, UNOS's geography-based approach. Join us for that next week on June 25th at 2 p.m. Eastern. Registration is also open for another transplant-focused webinar, which will focus on expanding the donor pool through utilization of perceived marginal organs. As some of you may recall, this webinar was originally scheduled to take place in March, but has since been rescheduled for a new date, which will be on July 14th at 3 p.m. Eastern. For more information on all of our upcoming webinars and to ensure you have the latest information, please visit our website at organdonationalliance.org. Now, for those of you who are seeking continuing education credits, we are offering one Step C credit and one nursing contact hour for this webinar. As always, we do also offer a certificate of attendance for anyone seeking CEs that are not being offered. Everyone joining us today is eligible to claim either of these credits or certificates, but prior to receiving your certificate, you will be asked to complete a brief online evaluation that will allow you the opportunity to provide us with your valuable feedback. If you're listening in a group, please be sure to get the evaluation email from your group lead. As a friendly reminder, you'll have 30 calendar days to complete your evaluations and claim your credits. Now, with all that being said, I'd like to go ahead and begin today's program by introducing our moderator, Jennifer Salm, Senior Organ Procurement Coordinator at the Center for Donation and Transplant. Jennifer, thank you so much for joining us today. At this point, I'll go ahead and turn it over to you to introduce our speakers.
Thank you, Deanna. Our first speaker joining us today is Alexandra Glazier. She is the CEO of New England Donor Services. Alexandra is the President and CEO of New England Donor Services, NEDS, an affiliation between two organ procurement organizations, New England Organ Bank and Life Choice. NEDS integrates clinical operations, staff, and leadership of two OPOs with the goals of increasing donation in the region and deriving financial efficacies. NEDS serves 190 hospitals, 14 transplant centers, and a population of 14 million people in 6 states. New England Donor Services has 220 employees and a $68 million annual operating budget. Prior to her current role, Alex was CEO of NEOB, where she developed the vision for an affiliation with Life Choice and negotiated the creation of New England Donor Services. Other NEOB accomplishments under her leadership included coordination of over 1,000 organ transplants, a 42% increase over 2015. Also, the first HIV-positive organ donation for transplantation under the HOPE Act, and the first genitourinary vascular composite allograft transplant in the United States. NEOB was named Boston Globe Top Places to Work in 2014, 2015, and 2016. Alex currently serves on the OPTN UNOS Board of Directors and previously chaired the Ethics Committee. She held a 6-year appointment on the U.S. Secretary of HHS, Advisory Committee on the Organ Transplantation, ACOT, She has worked to address regulatory barriers to conducting clinical trials in transplantation and has twice presented on this topic to the Institute of Medicine. Alex is chair to the Legislative Committee for the Association of Organ Procurement Organizations, AOPO, and a consultant to the Donate Life America, including work on the recent Apple venture. Previously, Alex was NEOB's VP and General Counsel and has practiced health law at the firm Ropes and Gray. Alex holds an undergraduate degree in bioethics from Brown University and a JD MPH from Boston University, where she serves as faculty. We also welcome Brendan Parent. Brendan Parent, JD, is a Director of Transplant Ethics and Policy Research and Assistant Professor of Bioethics in the Division of Medical Ethics at NYU School of Medicine. He has co-led international working groups on emerging ethical issues in vascularized composite allografts, researching manufactured organs, and revising the Uniform Anatomical Gift Act. His current research focus is on ethically expanding procurement after circulatory determination of death in the United States. Parent is editor-in-chief of the Health Law Journal for New York State Bar Association, a fellow of the Center for Genetics and Society, and policy advisor for the Bellevue Hospital Ethics Committee. His work has been featured in the Washington Post, Chicago Tribune, and on NPR. Brendan joins us today after authoring and co-authoring multiple fascinating works on the ethics behind DCD, manufactured organs, and other topics surrounding donation that deserve a more thorough discussion and deeper look, which Brendan has provided for us through his writings. We thank you for joining us today. Alex, if you would like to bring us into the first topic of the legal frameworks of DCD, we would love to hear you speak.
Okay, great. Thank you so much for that kind introduction. And I'm really pleased to be talking about this today. I thought what would make the most sense would be to provide an overview of the legal frameworks that underpin our practices of DCD, and then hand it over to Brendan to take a look at ways that we have been able to innovate and stretch those practices over time, but tie them back to where we started with the legal parameters under which we work. And so the very first thing I wanted to do is to show everyone how much we have increased DCD over the years. This graph starts in 2001. There were 167 DCD donors that year, which was less than 3% of the national total in 2001. And if you go about halfway through this graph to 2010, we achieved just about 950 DCD donors, which was 12% of the total deceased donors that year. And then most recently, for calendar year 2019, we're showing 2,718 DCD donors, which equates to 23% of the total deceased donors in 2019. And for all of us in the donation and transplant community, we know that there were very significant gains in brain dead donors during this time period as well. But I think the dramatic increase here is really important. And it's important for a couple of reasons. One is that we know from a number of studies that our biggest opportunity to expand the availability of organs for transplantation is in the DCD population. And it's also important because what this graph is showing is in terms of the time frame that this occurred in the same period of time where there was rapid development of the donor registries and use of first-person authorization. And we're going to get to that in a minute. But again, striking the amount of increase in DCD in the U.S. over this time period. It's a 16.3 times increase from 2001 to last year. So when we think about the legal frameworks of deceased donation, I'm going to start with just some basic ideas, which is that the laws governing organ donation in our nation are state-based. And so we think and hear about uniform laws. And the reason why we have uniform laws is because this is an area that's legislated at the state level, and yet we want to have consistent national policy so that organ donation is experienced under a similar framework regardless of which state it occurs in. And so uniform laws are designed to do exactly that, provide some national consistency in areas that are delegated to the state's power in order to regulate. So this occurs in completely other areas, financial areas, for example, the Uniform Commercial Code being the best example for those outside of the field. But for us, we know that organ donation has uniform laws. And so while they are uniform, there also are some differences from state to state, and that can end up being important when we get into some of the granularity. Donation is, of course, conducted at the state level. The activity of organ donation is governed where the activity occurs, whereas when we think about transplantation, which involves the movement of resources across state lines, and that, of course, triggers the authority for federal regulation, and therefore we have a federal system regulating transplantation, but we have state laws governing the act of donation itself. So that leads us to the two primary sources that we look to for legal frameworks that we operate under for deceased donation. The first is the Uniform Determination of Death Act, or the UDDA, and the other is the Uniform Anatomical Gift Act. And I'm going to take a look at each of these with regard to DCD in the next couple of slides. So I think one question to start with is, what's different about DCD that leads to this entire conversation being with different concerns and considerations from a legal perspective than brain dead donation. And so it's these two critical process points. One is that there needs to be a withdrawal of ventilator support prior to the declaration of death, and then the recovery of donated organs. And the other is that death in these cases is declared based on circulatory cessation. And both of those have an impact under the law. So the first is that we know because withdrawal is a necessary component of being able to coordinate DCD, that there needs to be legal permission, consent for that withdrawal, as well as the authorization for donation. And this is different than in brain death cases where there is no withdrawal that's required, and the brain death declaration itself is a diagnosis not requiring permission or consent. And the second is that the diagnosis of death in DCD is based on that absence of circulation versus an absence of brain function, and that triggers a different part of the UDDA. So taking a look at the UAGA first, and this is hopefully review for most watching this, the Uniform Anatomical Gift Act is the legal framework we use for permission for deceased organ donation. It's based on gift law principles, and so we use the term authorization, which is another way of saying legal permission, but as distinguished from the concept of informed consent, which is utilized frequently for healthcare providers, the facilitated understanding of risks and benefits when a patient's making a decision regarding treatment alternatives. Not applicable concept for deceased donation because there's neither risks nor benefits for the decedent when the donation is going to occur. And so when the Uniform Anatomical Gift Act was put together, the legal structure that was selected was gift law, as that really fit the realities of deceased donation, that the gift is the voluntary transfer of the organ from one individual to the recipient for a specific purpose, and the Uniform Anatomical Gift Act limits that purpose to transplantation, research, or education in that priority order. So one of the other things under the UAGA is that the gift is conditional, that although it is authorized in advance of death, the organ can't be recovered until the individual has died, and also that the organ is suitable for the purpose it's being gifted for. So, for example, that the organ is clinically suitable for transplantation. And of course, those of us in OPOs in the field of donation realize that there are many individuals who have registered as donors who would like to be donors but may not die in a manner where clinical suitability makes that a possibility. So all of these components are wrapped into the UAGA. And I think that when we then consider how the gift can be authorized, the primary individual to make that decision is an adult, him or herself, prior to death. And of course, this is the basis for first-person authorization. And for those of you who may not know, so historically, this isn't new. In fact, this was in the very first 1968 version of the Uniform Anatomical Gift Act, that individual decision-making was always prioritized under the statute. But really, until we had donor registries, there wasn't a mechanism to operationalize that. Donor cards were, not found at the time that they were needed. And so there was a default practice to request permission from the surrogate decision maker, which under the statute is prioritized after the individual, him or herself. So an adult making their own decision under the UAGA always occurs prior to death, and this becomes important for one of the questions that we tend to get about how first-person authorization and DCD work together. So keep in mind that when you go to register, you're going to register as a donor, of course, while you're alive. So that decision is always made prior to death. The UAGA governs donation after death, but there's nothing in the statute regarding how death is declared. That's not material. What the statute provides is that you can authorize a gift of an organ for transplantation after your death. So the statute governs donation after death regardless of how death is declared, and donor designation authorizes donation after death regardless of how death is declared. The mechanism of how a diagnosis of death is made is, again, not incorporated into the UAGA because from a legal perspective, it doesn't make any difference. The point is that individuals have the ability to authorize a gift after their death. The recovery of that gift, the surgical removal of that organ for transplantation, can only occur when the condition of death has been met. So the key piece being that permission can be granted in advance, regardless of how death is going to be declared. There's no difference in the statute one way or another regarding that diagnosis. And then the condition of death is required, of course, for the recovery of those gifts. So we also know, though, that authorizing donation doesn't authorize withdrawal of support. And I think this is where a lot of the confusion can initially occur, that surrogate consent, and I'm using that word carefully, surrogate consent for the withdrawal is required in all cases. And we also know that withdrawal has to be accomplished and coordinated in a way that will allow DCD to proceed. This has to do with the timing of the withdrawal, the manner, maybe even the place of where the withdrawal is going to occur. So the orchestration between the permission for donation and the withdrawal needs to be carefully managed, but they are, in fact, two different concepts. And so I have put together just this very basic graphic, and the purpose of this is just to show that the withdrawal of support is a separate decision, and it follows a different legal framework than the anatomical gift. So the anatomical gift, as we mentioned, under the UAGA, the fact that death is declared one way or another is not relevant. What's relevant is that the gift can be made in advance and can be recovered after death. Whereas the withdrawal of support is a healthcare decision. The individual is alive at the time that decision is made, if they're unable or incapacitated to make that decision themselves, which is the vast majority of the time, then the surrogate can exercise that decision for them. But that is a separate and distinct decision under the law. So I've already mentioned that the timing is really important, and I think one of the questions that comes up is whether sometimes I'm asked whether the dead donor rule precludes discussion of donation prior to death. People will say, well, but you can't, the DCD potential donor has not died at the point that the OPO has arrived at the hospital. And yes, of course that's true. But I think, again, separating out conceptually the withdrawal decision from the donation decision helps to resolve what can otherwise seem a little bit confusing. And also to point out that, hold on before I go to that one, that there are many cases where a potential brain dead donor has also not been declared at the time that the OPO is at the hospital or speaking to the family. There's nothing in statute or regulation that precludes discussions of donation prior to the death of the potential donor. And in fact, one of the big ethical concerns that's been raised in the past about discussion and authorization of DCD was based on an IOM report, an Institute of Medicine report now called the National Academy of Science. This is more than 10 years old now, where the IOM said there really ought to be a decoupling, that the decision to withdraw should be made independent of and prior to the donation discussion. And so that would create this ethical firewall between those two discussions so that you wouldn't have the tail wagging the dog, so to speak, that the desire to donate would not interfere with making an independent decision about the appropriateness of withdrawal. But I think one of the issues with the Institute of Medicine report from the lens of 2020 is that this was drafted and considered in the context of surrogate consent for both. So there was an assumption in this report that both decisions would be made at the same time and both by a surrogate. And so therefore, the timing or sequence of when those discussions happened was important in order to maintain this decoupling. But we know that actually that's not the reality we live in. About 50% of potential donors are registered as a national average, which means it's not the rare case, it's the average case, where the potential donor has already made a donation decision. And so in effect, that early decision prior to that hospitalization very effectively decouples the donation decision from the withdrawal decision, because the donation was authorized well in advance at a different time prior to the hospitalization before the surrogate is considering the withdrawal decision. So I think when you separate out first-person authorization, it really provides a significant ethical firewall, if you will, between these two decisions for DCD when you have a potential donor that has already authorized organ donation and the surrogate needs to authorize the withdrawal. And what this leads to then is the ability potentially to have earlier conversations with the family, which we know is beneficial, that families, when they have struggled with sometimes for days about making a withdrawal decision, and then they're told organ donation is an option, but it will require another 12, 24, 36 hours, that time frame sometimes is overwhelming. It's too much. They've really just had enough, understandably. And so that can be a major deterrent to moving donation forward. So at least with regard to those potential donors that have authorized the donation in advance, I think that our practice in New England has been to talk to families much earlier in the process so that they know what the donation process will look like, what will occur if the withdrawal decision has been made. So shifting a little bit to once we have authorization, then what is the other legal framework that comes into play, and that's the Uniform Determination of Death Act. And so under the UDDA, there's two criteria for a death declaration. that have to, one or the other has to be met. Either there's been irreversible cessation of circulatory function, or there's been irreversible cessation of whole brain function. And I should say that while the entire UDDA has not been enacted in every state, it has been adopted as a standard in some form or another in every state. So we do have some uniformity there, although again, there can be slight variations, but in the component of irreversible cessation, I believe, is standard nationwide. When we think about irreversible, we're talking about cannot. So when something has irreversibly ceased, when circulation has irreversibly ceased, it means it cannot be restored. When we use the word permanent, we mean it will not. Circulation will not be restored. And although the UDDA uses the term irreversible, this has been interpreted and understood over time as meaning permanent. Circulation will not be restored versus cannot be restored. And this has been a very important interpretation in terms of supporting DCD protocols. Because we know that the premise for a declaration under the UDDA is that the circulation has to have ceased. And we use the permanent standard for these two reasons. We ensure that there's a waiting period in the protocol after asystole that's long enough to ensure that there will not be an auto-resuscitation. And we know there will not be any artificial resuscitation because the DCD is occurring in the context of a planned withdrawal. And again, the exercise of the patient's legal right to have a withdrawal and not to be resuscitated artificially. So we know that the circulation will cease permanently and irreversibly. The declaration of death in DCD in this manner then adheres to the dead donor rule because the circulation has ceased and the recovery of organs is only going to occur after that time frame has passed, such that we know there won't be an auto-resuscitation, and we know that there won't be an artificial resuscitation, again, in the context of a planned withdrawal. So the UAGA adds another layer of protection to make sure that conflicts of interest are avoided by prohibiting members of the transplant team from making that death declaration. The other thing to point out is that the UDDA incorporates this phrase in accordance with accepted medical standards to encompass the fact that medical standards do evolve over time. But I think it's important to say that this is not intended to allow the definition of death to evolve over time with medical standards, but rather to acknowledge that how death is diagnosed, for example, what tools, what tests are being utilized, will evolve. It does evolve over time when making the diagnosis of death, and we've certainly seen that, for example, in the brain death context. So how the diagnosis is made may change over time, but the definition itself remains anchored in the UDDA. So we know that then incorporating these legal standards, the protocol really has to support that medical determination that circulatory cessation has ceased permanently using the interpretation that's been widely accepted or irreversibly. And then my last slide is just that understanding these legal standards helps our community support the best ethical practices that we can. The law is always a floor. It's never a ceiling for what we should be doing in the community. I think that as an attorney, when I look at these protocols, I'm looking for precision as to when death occurs, how it's declared, and how it maps then to the legal standards, that we have transparency to the broader community of how we're doing this work, how we're incorporating these legal standards into our ethical practices, so that ultimately all of this work to broaden the availability of organs in appropriate ways can maintain the public trust that's really vital for all of us to achieve our mission. So with that, I'm going to hand it over to Brendan, and I'm sure that we'll be back online I'll be back online at the end for more questions. So over to you, Brendan.
Perfect, thanks. I'm just going to take a moment to make sure that people can hear me. If I don't hear anybody complaining, I will assume that my audio is okay. So thanks to the Alliance for the opportunity to speak, and thanks to Alex for that comprehensive and engaging history. I wish I could just implant that exact presentation into all of my students' brains. That would really help a lot with all of the classes on ethical issues in organ transplant. I'm going to focus in on ethical issues in heart donation after circulatory death, specifically in controlled circumstances, meaning hospital situations where there will be withdrawal of life-sustaining treatment, as Alex mentioned. I'm going to do so in context of the evolution of preservation and procurement methods. Before I do that, a quick disclosure. I received some salary support from an organization called United Therapeutics that works on bioengineering organs. And I'm on a couple of NIH grants that are currently under review to study these issues. And while I am an attorney, nothing I say here today is legal advice. And the views I present here are mine and do not represent those of NYU or any other institution with which I'm affiliated. So to start, let's start at the beginning. The original method for donation after circulatory determination of death is direct procurement or rapid recovery, which is still used today. And this is what it sounds like. A decision is made to withdraw life-sustaining treatment. This is executed. The decision is executed. The patient progresses to circulatory cessation. The hands-off period is exhausted, and then the organs are procured. And under this method, we either co-locate the donor and the recipient, which was done when this first began, or more common, we then procure the organs and cold store them to transport them to the recipient. This method, while we can assess the organs for their functional viability in the patient before death, it limits the ability to reassess them after circulatory death before attempting to transplant them. And obviously, the ischemic time, or the time that the organs are not being circulated, does have an impact on their functional quality, which is difficult to know until the transplant has taken place. And another issue is potential discord between the various organ procurement teams, lung, heart, liver, etc. As soon as circulation stops, understandably, everyone wants to get the organs quickly to ensure their viability for transplant. So some ethical issues regarding donation after circulatory death that are not specific to heart and that Alex touched on a number of, I want to recap and put a little bit more nuance on. First, with regard to the timing of the withdrawal of life-sustaining treatment versus the donation conversation, there is a pervasive myth in the organ donation sphere that being registered as an organ donor or consent to donation will influence the quality of care at the end of life. And a number of individuals out in society, when you ask them, why have you not registered to be a donor, they say, well, I want the EMTs to try to save me, right? And so this gets back to the IOM report that Alex was mentioning, which presented the notion of the ethical firewall to ensure that decisions to withdraw life-sustaining treatment are made completely on the basis of what is in the best interest of the patient as a patient without concern for organ donation. And so this is very important and made a little bit more complicated in the case of donation after circulatory death, because we have to tread carefully when a family, as Alex said, makes the decision and then is ready to move on, but we still need to have this conversation after the decision about organ donation in a sensitive way to allow the family to understand the value and potential benefit that can come out of this tragedy, while still respecting the desire to withdraw care. Another ethical question is, what are the measures that can be taken before the patient dies that are explicitly and solely for the purpose of evaluating the organs for donation and preparing the organs for donation? Examples include potentially cannulating the veins, administering this molecule here in the image, which is heparin, for those of you OChem majors, and potentially relocating the donor to make it easier to facilitate transplant. So the question is, what can clinicians ethically do with to the patient that are not for the patient's benefit, but for the organs for purposes of transplant? And I think there's a fair bit of ethical consensus that these kinds of measures are acceptable as long as they are neutral in terms of not causing harm or suffering for the patient, that the surrogate decision maker, I distinguish from the authorized decision maker, but the surrogate decision maker for healthcare purposes agrees to these methods. And in some ways, it can be argued that these measures are in the patient's interest or well-being to help realize their wish to be a donor. The final issue I'll talk about here is what is the acceptable hands-off period, i.e. the amount of time after circulatory cessation that the procurement team has to wait before starting the procurement process because of the possibility of autoresuscitation, which is the heart restarting on its own. Now, the cases of autoresuscitation are very rare, and when it happens, only happens for a matter of seconds or maybe minutes, and has, to this date, as far as I know, not led to any meaningful long-term recovery of any patient. But the mere fact that the heart beats again seems to fly in the face of a declaration of death. So the hands-off period is critical, but whether we wait 2 minutes, 5 minutes, or 10 minutes varies according to institution. And I think to be ethically consistent, we need to reconcile this time frame and put some effort into that going forward. The ethical concern specifically regarding heart donation after circulatory death is the following. If we use the heart to declare death, i.e., we say that the person is dead when the heart stops beating, but then we restart that heart in a new recipient, does this undermine the fact that we declared the person dead? And I think the answer to this question depends on the definition we use for death. And I will mention or refer back to the Determination of Death Act. And as Alex said, the UDDA itself is not binding law. It is put out by the Uniform Law Commission, and then each state is left to decide whether to adopt it in whole or in part. And all 50 states have, in fact, adopted a Determination of Death Act with minor variations, but all have the relevant part, which is a person is dead when there is irreversible cessation of circulatory and respiratory functions. But the irreversible standard, and please excuse the glib image, is a high bar. And this high bar means that the heart has stopped and cannot restart on its own. And this in practice means that very few people are dead according to the irreversible standard because technology has gotten to the point where we can restore some amount of circulatory function for a lot of people for whom it has ceased. So we have to do this replacement of irreversible with permanent in practice, which is instead of saying the heart has stopped and cannot restart, we say the heart has stopped, it will not restart on its own because we have exhausted the hands-off period, and we will not attempt to restart it because it will not lead to any benefit. Now that's a critical point which I want to return to, but the idea is that we will not attempt to restart it, and why? So this replacement of irreversible with permanent allows us to declare death in practice, which is useful, but does it help with this issue of heart transplant? And the fact is that when the heart stops and we transplant it into another person, we do in fact restart it. So does this in practice undermine the determination of death because we are restarting the heart in someone else? And a quick answer to that question is the heart working in the recipient, i.e. saving the life of a transplant recipient, absolutely does not mean that the heart will work in the donor. The heart is a symbol of multi-system failure, which means the death of the individual. But if we are merely using the heart as this sort of endpoint or a representation of multi-system failure in the patient, perhaps we need a different definition of death, which is the irreversible loss of functioning of the organism as a whole. So this might be more philosophically sound as a definition, but it does set an even higher bar, right? So how do we implement this in practice? So I'd ask you to imagine a picture of a frustrated clinician in the corner of the slide. I couldn't find one that I liked well enough, because how will the clinician use this definition to actually declare death? How many functions need to be ceased? Do we need to see zero function in the whole body? What about the fact that nails and hair continue to grow? It's just not workable. So we need to return to this notion of permanent cessation of function, and I believe put some more work into that definition in light of new technology and practices. Advancements in procurement and preservation include direct procurement followed by ex situ normothermic regional perfusion. It is a mouthful. It basically means that the decision is made to withdraw life-sustaining treatment. That decision is executed. The patient progresses to circulatory determination of death, to circulatory cessation. The hands-off period is exhausted. We procure the organs and then put them in this fantastic machine which perfuses them outside the body. So that's what ex situ NRP means, is that we put the organ into the TransMedics organ care system where the organ is perfused and remains viable, and this significantly limits ischemic time, i.e. the injury without circulation. It allows some amount of evaluation of the heart's quality after it has been removed from the donor. However, it's pretty costly. This is still pretty new technology. Each instance of preservation might cost about $40,000 and is only currently available in about 18 centers across the U.S. And evaluating the organ in the organ care system doesn't allow us to really understand how it is going to function in concordance with and support the function of other organs. So these facts have led to resurgence of interest in another practice in the U.S., which is practiced in other countries, called in situ NRP, which means that the patient, a decision is made to withdraw life-sustaining treatment in accordance with medically accepted practice and standards. That decision is executed. The patient progresses to circulatory determination of death, circulatory cessation, hands-off period, and then the blood flow to the brain is precluded by clamping the internal carotid and vertebral vessels, which facilitates what would otherwise be the natural progression to brain death when the heart stops. Then, after those vessels to the brain are clamped, we reinstitute circulatory support for the organs using either circulatory bypass or ECMO. And this allows us more time to evaluate the organs under physiologic conditions, i.e. see how the heart will support the liver and the lungs, etc. And it might mitigate the actual ischemic impact to all organs, even compared to the ex situ NRP method. So I can imagine, for those of you who are just hearing about this the first time, that some of your eyes might be raising, saying, you're doing what? You're restarting circulation? Which leads to these questions about this process. If we restart circulation in the donor, are we in compliance with the determination of death? Clearly, this death does not meet the irreversible standard, which is that circulation cannot restart, but doesn't meet the permanent standard, i.e. that we will not restart circulation because we are in fact restarting circulation. And we're not doing it in another body, we're doing it in the same body. So to answer this question, we need to think about what the permanent standard actually means or implies to find out whether we are in compliance with the dead donor rule, as Alex was mentioning. The dead donor rule meaning that ethically we cannot remove organs thereby causing death. Now, the dead donor rule is not codified. It is not law anywhere, but it is an ethical rule with which all centers comply to do this process correctly, safely, the way it should be done. So does this method, restarting circulation in the donor after a declaration of death, cause death? The no argument, saying that it does not, hinges on believing that the patient was already dead, i.e. that if the withdrawal of life-sustaining treatment is justified on grounds that continued medical care is not in accordance with accepted medical standards, and the patient progresses to circulatory cessation, the hands-off period is exhausted, at that point, the patient is dead, and what happens after that point does not bear on the patient's well-being and is in pursuit of organ donation. The counter to that is the physicians are actually preventing blood flow to the brain. They are actively ligating those vessels because why? An argument is to prevent circulation to the brain, to prevent the possibility of experience for that patient, no matter however limited, and thereby that action makes the physicians complicit in the donor's death and is not in compliance with the dead donor rule. So think about that for a moment, and I'll just ask to consider a parallel, which is the patient or the potential donor who is going to donate, and the methods used will either be rapid recovery or the ex-Situ NRP. When that patient has life-sustaining treatment withdrawn, and the clinical team chooses not to restart circulation after it has stopped and instead procures organs, are those clinicians violating the dead donor rule because they are actively choosing not to restart circulation in that patient? They can, but they do not. This is clearly not a perfect parallel, but I think it's important to explore the feasance, non-feasance distinction, the idea of acting versus inaction when deciding whether the patient declared dead is in fact dead. There are some people who say, you're doing linguistic acrobatics to make the definition of death correspond with what you need to get organs. Instead of doing that, just admit the patient is not dead, but allow the procurement of organs from living patients under limited circumstances, i.e. those who are imminently dying and for whom we have declared continued care medically ineffective, thereby abandoning the dead donor rule. But if we do this, I would ask, does that then allow the possibility of organ donation motivating the desire to withdraw life-sustaining treatment? And if we allow organ donation to, even in part, even minimally, motivate the decision to withdraw life-sustaining treatment, then do we open the door to implicit biases creeping in to the decision of when to withdraw, i.e. that because this patient is a member of a particular group, whether intentionally or unintentionally, we are saying that this patient is ready for withdrawal because the value of their life isn't as significant, and so we can do this a little bit sooner. We need to preserve trust in the medical institution, and I question whether abandoning the dead donor rule will promote the myth that we talked about at the beginning, which is that being an organ donor or the possibility of organ donation might change the quality of care at the end of life. The final issue I want to discuss is authorization. This is, as Alex mentioned, not informed consent. It is different. Informed authorization of donation requires information, but what kind of information, right? Obviously, we're not going to tell every patient and authorized decision maker or a potential donor, what goes into the processes of preservation, procurement, and donation. Not every single detail, just the same as we don't tell a patient going in for surgery everything that's going to happen to them when they go under anesthesia. So what is critical information, especially with these new kinds of protocols, to make a genuine ethical choice? So I'm asking you, listeners, would you agree to the in situ NRP process as a donor, knowing what you know now? And how much information would you want if I haven't already given you too much information, right? Personally, I believe in the firewall. I believe that a decision to withdraw life-sustaining treatment for me would be motivated by the fact that continued care would not lead to medical benefit. I trust my healthcare proxy to support that decision. And that when I progress to circulatory cessation and a hands-off period, that at that point I am in fact dead, and decisions and processes thereafter will not bear on my quality of life. They instead represent efforts toward the public interest and promoting organ donation, which brings me back to the permanent standard. When decisions are made to withdraw life-sustaining treatment, they must be warranted and they must be transparent, i.e., what does the decision mean when we say we will not attempt to restart circulation because it will not lead to medical benefit? Well, what is benefit? What are the chances of regaining consciousness, of being able to get up and walk around and interact with the world? We need to be explicit and clear with surrogate decision makers, and when that is clear enough, then decisions thereafter are warranted for organ donation. And I will stop there.
All right. Well, thank you, Alex and Brendan, for such a comprehensive presentation. At this point in time, we'll go ahead and transition into our Q&A discussion. But just as a brief reminder to our participants, if you do have any questions for our presenters, please be sure to submit them using the chat feature. Again, that's going to be located on the bottom left-hand side of your screen. Additionally, during the Q&A discussion, I'm going to have this poll up. So for those of you who are participating as a group, if you could please just complete this poll to let us know how many people are participating in your respective group, that would be greatly appreciated. That being said, I'll go ahead and turn it back to Jennifer to moderate our Q&A discussion. Thank you.
Thank you, Deanna. Brendan, just a quick question, and for you as well, Alex. When families are approached for authorization for DCD, how much, as you had mentioned before, how much do you think that they should be told about the methods of preservation and procurement?
I would love for Alex to start with this one, and then I'll chime in if I have anything useful to say.
Sure. I mean, I think that ideally staff who are working with families take the family's lead on how much information is wanted. And I think that does vary very significantly. That we know there are some families who want a lot of detail about the process and some that really don't. And I would separate out, though, the fact that we, again, have kind of two decisions going on, and the answer may also differ on whether this is an authorized donor, but that we've got the withdrawal decision and some of the logistical components of how the withdrawal will be orchestrated with the coordination of the recovery of donated organs. And then we also have what's going to happen when the organ is recovered or being recovered. And I think it's generally best for the staff to take the family's lead on what level of detail. When we're talking about deceased donation, again, we're not talking about the informed consent standard, but we do want to ensure that we have the level of transparency and also information for families that really want that information and understand it before then the process unrolls. I don't know if you would add anything, Brendan.
No, that's great. I would not add anything to that.
Alex, speaking of transparency a little bit, what do you find to be one of the challenges to DCD? One of the questions that we have here is that when a family brings up withdrawal of care, there isn't always an OPO representative or someone there directly to speak with the family. And one of the barriers that we find to DCD is that the OPO comes in a little bit too late because we often don't mention DCD until the family does withdraw care. So how do you see or how do you perceive that we can overcome that barrier and improve our DCD numbers in the future?
Yeah, I mean, I agree. I think that our own experience in New England is that timing is one of the biggest barriers to being successful in approaching families about DCD. And again, it stems back to this idea of decoupling that I think is pretty antiquated in terms of the way we coordinate and experience organ donation today. That when the decision to donate has already been made through a first person authorization through a donor registry, then the concern about approaching families, quote, too early is really removed because there's been a very effective decoupling of the decision to donate from the decision to withdraw. So one of the ways we've been working on addressing this timing barrier is to have much earlier conversations with families, at least in those cases where the potential donor has already registered. And again, having some ethical confidence that that's an appropriate discussion to have because the decision's already been made about donation. And we want to ensure the family knows that if withdrawal is going to occur, this is the timing that they should be expecting and setting those expectations early on for the family, and then also starting the process as early as possible, making sure when it's a registered donor that the OPOs are sending out serologies quickly, just as they would with a brain dead donor in advance, so that if there's going to be a rule out medically on that basis, that we would know early on and it wouldn't cause further delay. So I think there are steps like that that can be taken to try and move the needle on the timing issue. And then, of course, getting earlier referrals from the hospital. This is incredibly challenging right now in the middle of the pandemic, but under normal circumstances, trying to get into the hospital units much earlier so that OPO staff are available to have these conversations when we know that there's going to be a withdrawal decision. We want to be informed as an OPO before that discussion happens, once the care team has identified that that discussion is appropriate.
And have you had any true experience with a true first-person authorization DCD, such as a high spinal injury, gunshot wounds, people with ALS that have truly made it their wishes or have been able to speak with the OPO directly?
So, first of all, I have to object to the idea of true first-person authorization. Whether you give that permission today and you die 10 years from now, or you give it today with a planned withdrawal tomorrow, it doesn't make any difference. From a legal perspective and an ethical perspective, you're exercising your autonomy rights, whether it's now or it's later. So I really don't like trying to make some distinction like that. But in terms of a circumstance where we've had potential donors make their own decision to donate at the same time that they're also making their own decision to withdraw. Yes, we have had some cases like that in New England. I know other OPOs have as well. They can be challenging for the staff to navigate, but also really rewarding, knowing that we're able to accomplish for that individual the legacy that they really want.
All right, I'm not sure if we lost Jennifer, but it looks like that. Oh, sorry. Go ahead.
Yeah, I'm just, I don't think we have any other questions coming in at this point in time. I think that was our last one.
Okay, perfect. So that being said, we'll go ahead and conclude the Q&A discussion. And with that, I'd just like to give a few closing remarks and extend a sincere thanks to Alex and Brendan once again for putting together such a well-rounded, beneficial, and I think very timely discussion on the legality surrounding DCD practices. So thank you for your efforts in coordinating that. And additionally, thank you to Jennifer for your efforts in actually coordinating today's discussion and getting our two presenters on board to facilitate the discussion. So thank you for that. And to our participants, we thank you for joining us today, and we hope you found this presentation just as valuable, and we hope you continue to stay safe, and we wish you a wonderful rest of your day. Thank you, everyone.